First off, I want to thank both of you for coming in this evening on behalf of Veterans in Politics. We appreciate it very much. This endorsement interview is sponsored by Tim Treffinger, who's running for Clark County District Attorney. This is not an endorsement by any of the candidates that are here today. I just want to start before I get into the process, giving you guys a breakdown of the rules of this process. I just want to thank both of you for running for judge. And the reason why is because I believe that this great nation is one that was founded and based on common law, and those that are responsible to make sure that those laws are followed in accordance with the Constitution are judges. And we here at Veterans in Politics International take that responsibility very seriously. Overview of the process. First, the panel members will give a 30-second introduction of ourselves. Then the candidates will be given 1.5 minutes to introduce yourselves, what office you're running for, and why you are asking for our endorsement. Please keep in mind, this is not a debate. It's an interview, so neither one of you can ask each other questions. Once a panel member asks you a question, you'll be given 2 minutes in order to answer that question. I won't be rude and stop you right at 2 minutes if you're in the middle of finishing up a point, but I want you both to be respectful to each other. At the end of the question and answer portion, each candidate will be given 1 minute and 30 seconds to make a closing statement on why they're the best candidate for this office. Okay, I'll start by introducing myself. My name is Jim Jonas. I am a director of Veterans in Politics International, and I have been a proud member of Veterans in Politics International since 2008, and I look forward to listening to your answers to our questions. Thank you.
My name is Stephanie Phillips. I'm a real estate broker, and I've been in the real estate business for almost 30 years here, and I've lived here almost 30 years as well. I'm a mom. I have a 20-year-old and a 17-year-old. She's a senior in high school. And I just launched a nonprofit called denmothers.org, and I'm glad to be here.
My name is Van Miller, and I am a documentary filmmaker and a content creator. I do podcasts as well. And that's what I do.
Okay, Mr. Kurth, nice to see you again. Do you want to go ahead and start with your 1.5-minute introduction, please?
Sure.
Go ahead and just pick the handheld mic up there. Thank you.
Ready?
Thanks, Rob. It's on.
All right. And I apologize because I probably need to look this way, but you're over here. So my name is Robert Kurth. I'm running for Family Court Judge Department A. I grew up here in the Las Vegas Valley. I attended El Dorado High School and went to BYU. Then I came back and got my degree in business from UNLV. Then I went to law school in the University of Denver College of Law after my second child was born. Had 2 children during that time. My third right when I graduated, after I graduated law school in December of 1991. I came back here to Las Vegas because that's my home and where I wanted to make and build my practice. I grew up in a blue-collar construction industry and family, and I've been practicing law here since 1992, practicing family law for 30 years now. I'm also licensed in the state of Utah since 1994. I do a little bit of work there, but most of my work here. I also, when I was growing up, I had to learn responsibility, learn how to work hard. I worked construction full-time for 3 years while I attended UNLV full-time and had my wife and children. I have 4 children, 3 grandchildren, 3 dogs, and my children I'm very proud of. Everything that they've accomplished. One has a master's degree, 2 have bachelor's degrees, and one has a associate's degree and is an esthetician. And I look forward to answering any of your questions today.
Thank you, Mr. Kurth. I know I'm going to mess your name up. Last name, Parlade.
You got it.
Miss Parlade, go ahead, please.
Thank you so much. Thank you for having me, Jim and Stephanie and Vem, and thank you, Veterans in Politics, for having me today. My name is Mari Parlade, and I am running for Family Court Department A. My husband is here with me today. He is a disabled U.S. American veteran. He served in the U.S. military for 4 years before getting disabled, and he is also 5 generations military. So I come here and I thank you for your service and for allowing me to be here today. I am a children's advocate, first and foremost. Children and families are my heartbeat. I began my legal career representing children, to be their voice, to represent their wants, their wishes. That was the foundation of my legal career, so that I can come and put my needs, my desires, and my expectations aside to really come to listen to and understand my client. Children and families are my heartbeat. I first represented children pro bono for about 5 years while being a small business owner here in Las Vegas. I had my own law practice, represented families in family law, homeowners association, litigation, real estate litigation, but my heartbeat was always to represent the children. After serving as a pro bono attorney for at least 5 years, I received congressional and senatorial recognition for those accolades, but I did it all really because I wanted to represent the children. After 5 years, one of the judges suggested that I put my name in to be a judge pro tem, and I did that, and all of a sudden that took off, and I had to close my law practice down because I served on all the courts in family, from domestic violence to TPOs, to drug court, to juvenile abuse and neglect, juvenile delinquency, truancy court. It wasn't a matter of whether I was sitting, but which court and assignment I was going to take. I enjoyed my time sitting as an alternate hearing master, such that the court even appointed me to be the chair of Courts Catalyzing Change, which was a model court initiative to address disproportionality and disparity in our child welfare system and in our court systems. When I led that as a judicial officer, I reached out to the community first and foremost, to the families and communities here in our own city, because I know that we can't, government, church, we can't do this work alone without partnering with our community, with our families, and with our churches. And so when I did that, I partnered with the churches, I partnered with our community to really sit and listen about the needs of our community and our families. I led Courts Catalyzing Change for 2 years, and then I was moved over to the Department of Family Services, where I was hired to create the legal division for the child welfare system. I deal with everything from administrative law, appeals, to litigation, to legislation. And in doing so, I have placed children and families at the forefront of everything, even if it's at the point of having to overturn the agency for the sake of children and families. I am a staunch believer in applying the law to the facts, but doing it with a heart of compassion. I have been recognized by our mayor here in Las Vegas as the Compassionate Cities Award winner for strengthening families because of the work that I've done in our community.
Okay, Maria. Can you wrap it up?
Thank you. And that's it.
Okay. I'll pass it on to either one of the panel members. You guys want to start with your questions? Them?
What are the current biggest issues of the family law industry? If you wanted to name, if you could even think of, but if there's 3 or 5 issues that you would consider trying to fix or proposing fixing, or even just naming the issues with the family law industry.
Whoever wants to go first, it's fine. Mr. Kurth, if you want to go, or Maria, whichever one. Go ahead, Maria.
Sorry, Mark.
Mari, yes, thank you. Thank you. Now, Mr. Miller, when you say the family law industry, do you mean the court system specifically?
Yeah, the family law court system, the social workers surrounding the family law court system, advocates surrounding the court system.
Absolutely, thank you. Well, with regard to the family court system, I believe that the challenge is that we don't have enough resources, as in judicial resources, caseworkers, and supports for our families. We have families that are on dockets. We have families that are having to have their cases continued and not able to get their day in court because of the burdensome calendars that are on the systems. We also have a dire lack of resources in our community, whether you're dealing with the child welfare system, where families now are inundated with trying to bring themselves to a place where they can bring their children back home, but oftentimes they're plagued with waiting lists. Maybe the family needs mental health treatment. Maybe they need drug treatment, but our state of mental health and drug treatment here in Nevada is in dire straits. So we have families that are in need of supports and assistance, in need of justice and decisions from judges, but they're not getting them because of the dire lack of supports, resources, and judicial resources as well here in our community. Not to mention the fact that there could very well be some inconsistency in some decisions that the families are experiencing depending on where they are assigned.
Mr. Kurth.
Thank you. In my representation over this 30 years, I've represented people from all backgrounds, races, ethnicities, income levels. And a lot of time I'm dealing with the ones that have to be on, say, a payment plan. So a lot of times I feel like some people are, they're afraid. They wait too long. They don't have enough education. We need to put something out there to explain the process to them, to understand. They're like that by them waiting is going to affect their custody case. That could have a detrimental impact on how they handle things. We need to get some of that out to them and some more resources for them, because I don't know what the percentage is, but I think about half probably are representing themselves, are improper person in the family court. I think, even dealing with child protective services, people need to understand what that is, even dealing with that, because all of a sudden child protective services comes out and somebody makes a representation to them. Now they might have a criminal case too, because they don't understand that when they're speaking to that representative, that those words can be used against them later on in a criminal court. And now they have a CPS case too they're dealing with. And now, if two people are married, one's got to be separated and find another place to live, or they're not going to give the child to the other parent until they get everything resolved. So there's a lot of issues there. I agree with Mari that there's a lack of resources and we need a lot more of that. I mean, just now we need, more foster parents, for instance, but we have to take care of the children, but we also have to take care of the people that they don't have the resources, Litigating and family law can become very expensive very fast. And there's, I deal with payment plans and I try to help people, but a lot of people don't. And then those people are punished because law and economics do go hand in hand.
So as I understand it, every court hearing is public, regardless of courtroom, right? So any member of the public can walk in and observe. Is that right? No?
May I speak?
Yeah.
It depends on the type of court hearing. For example, child protection hearings, those are considered closed hearings for a certain duration. When the child is initially removed from the home, the 72-hour hearing and then the adjudicatory hearing, those are considered closed hearings. Once a child is made a ward of the court and the goal is now to reunify, those can be open hearings.
Okay, so every other hearing would be open to the public and the judge records it's on video, right? So at what point would you have to turn off that video? Would that be appropriate in your courtroom to ever turn off, let's say there's misbehaving going on, or one of the attorneys is out of line, or litigants is out of line? Would you ever turn off the recording?
May I speak to that? Thank you for asking that question. When I served as an alternate hearing master for almost 4 years, once I called the case, the light turned on, and that's called JAVS, and that light did not turn off. I would not turn that light off or record it. Now, I would have to take a recess. There was an instance where the litigant in my courtroom was under the influence, clearly under the influence, and so I called the case, and the litigant started to get unruly and under the influence. So my marshal came forward and said, I think we need a timeout. And so on the record, I called a recess so that my marshal could do a breathalyzer test on the litigant. But I know that as far as when I've served as a judge, that light is always on unless I have to take a recess.
Yes. No, I think that the hearings are open, right? Sometimes you need to close the hearing, but the video is still going to be on and is going to create a record for whatever has occurred or happened in that case. Sometimes you need to close some things. when you're protecting some of the children and some of those issues that come up and some allegations that are made and things like that. But otherwise, no, it will be open.
And would it ever be appropriate for a judge to ask counsel to return a copy of that video after a hearing? Is that ever appropriate?
I would have to know the circumstances, but I can't think of a reason why, only if maybe they were disseminating something like on social media to try to attack or hurt or endanger, or, something like that comes off the top of my head.
And if an attorney is yelling at opposing counsel and telling them to shut up and being unruly, at what point do you censure the attorney in your courtroom? Or would you?
I have had those instances when I served as a hearing master, and I reminded the attorneys that they're to speak to me. Because when you're in court, you're supposed to speak to the judge and only address the judge. You are not at any time, just like this interview, we're not allowed to speak to each other. We're only speaking to you as the judge, answering your questions. When you're in a courtroom, it's up to the judge to ensure the decorum of the court, the civility and the respect. And when the opponents get unruly, it's time to, warn the attorneys that you need to speak with me and only me, and not address opposing counsel. And if it continues to get unruly, then the judge could take a recess for a brief moment to allow attorneys to calm down, maintain their composure, come back in. But if they continue to get out of line, the judge does have sanctions that could be applied. It's up to the court to do that.
I think a judge needs to have a good demeanor and be able to de-escalate a situation. Do their best to try to de-escalate it. There are some attorneys that I've dealt with through the years that I think try to rile up the other side or get somebody going or do something. But, we have our canons and our ethical canons and our civility. And if somebody's not complying with that, then I would warn them and I would remind them they need to comply with it. And if they kept going, I'd probably ask them to approach and discuss it. And if they did it, or I'd ask the marshal to take them out of the court if I needed to do that, and then have them come back in and think about it for a little bit, come back and then discuss it with them. If I needed to discuss it on the record, I would put on the record that we're not going to have that type of actions, right? That's what we're not here. Too many times in family court, what I've seen, and even representing litigants, is that people are too engaged, and we are attorneys hired to represent our clients, but we're engaged in representing the client instead of trying to represent the children too. What's in the best interest of children? That gets lost a lot of times in the arguments back and forth that's motivating these litigants. Okay,
so, and this is a question that I've been bringing up forever. Family court cases here in this state, not just in this state, not just in this city, but throughout the entire country, have gotten to the point where the costs are just so out of control. And one of the reasons why I want to hear from both of you how you would. We get this a lot. Here at Veterans in Politics, we have litigants, pro se litigants coming in all the time, talking about how the judge strikes them as being vexatious. And it's interesting to me that since the family court was actually created here in Las Vegas, either one of you can correct me if I'm wrong. I have not once seen an example of an attorney being deemed by a judge in family court to be vexatious. So I would like to start with Mr. Kurth on this, because you are a family court attorney right now. How do you come to, and I've heard something about Rule 11, like what do you think should be done about the fact that shouldn't attorneys in family court, if you were a judge, be seen as vexatious as well, not just the pro se litigants?
Thank you. I think that the term of vexatious litigant is And the reason is it happens with the pro per is some of them just keep filing a motion over and over. The judge denies it. Then they turn around, they file another motion or a motion for reconsideration, and they're asking the same thing because they're just not understanding what's going on, or they can't believe the court ruled the way they did. So they just keep over and over. And the other side might have an attorney that has to respond. I've been in that type of case before where the judge made a decision and things are going on and things are trying to get prepared, and the other side keeps filing motions. So the side with the attorney keeps incurring more fees, and more fees. But and some vexation litigants, I think they're just they're not very nice, right? And what they're saying or what they're trying to do in court, and they're just mad because they're not getting that money, right? They're not getting that child support or that spousal support, or they weren't awarded the property, or they're not getting the retirement or something. So attorneys, I mean, I think there's attorneys that file motions when they're not supposed to file. You know, we have a rule that says we're supposed to meet and discuss it prior and try to resolve it. But sometimes you have to do that, but the sides are so opposite of each other that they're not going to agree. You just have to file a motion and then try to work it out. Go to mediation, go to settlement conference. I try to do that, or have the judge make the decision. But the attorneys aren't usually just filing over and over the same type of things. That's why they're not vexatious. You know, it's the pro pers that keep filing by themselves. And, you know, every 6 months they want to file a motion to change custody or something, or every 3 months.
Mari, would you like to elaborate on that?
Yes, thank you for the question. And so, you bring up an excellent point, and I appreciate Tom for Robert for speaking about the pro per. I know that you were asking about the attorneys, so I'm going to kind of go straight to the attorneys. And attorneys, we are subject to our canons, our oath as attorneys. One of the rules is NRCP, Nevada Rules of Civil Procedure 11, that says that before an attorney can file a document, we have to also testify that, or attest that it's not filed for the purpose of undue harassment or for delay, or that it's a frivolous motion, or that it's a basis claim, that it's rooted in some law, or at least a good faith effort to maybe assess a different interpretation of the law, and at least some reasonable point of evidence. We can't just throw things out there like you're throwing spaghetti on a wall and just putting your name, because we're attorneys. We're held to a higher standard. And so the NRCP 11 is something that is instilled to keep attorneys at bay so that we're not just engaging in this vexatious litigation. If there are pro pers doing it because they don't understand, that's different. But that doesn't mean that just because they're doing it, we have to keep doing it as well. And judges are held to a judicial canon. And in Rule NRCP 11, it actually gives judges the opportunities, if they find that an attorney is violating NRCP 11, the court can actually sua sponte address that. So it doesn't have to, because what if you have an unequal playing field? What if you have a pro per that's vexatious and filing things not for any other reason other than they just don't know? But then you have an attorney who's going on top of that. The court has a duty of care to maintain decorum and civility in the courtroom and uphold the rule of law.
Often when a litigant is called vexatious, it's usually like they're trying to have some form of custody of their child and they're being blocked by the courts. Would you consider somebody vexatious to be reapplying if they are just trying to essentially see their own children?
Either one of you. Whoever wants to start, that's directed to both of you.
Well, if a parent's trying to seek custody of their child, they do have a right to file it before the court. And if they don't have an attorney there is the self-help center that can also assist them with some guidance on looking at the law and the factors that are involved to, establish the best interest of that child. If they've already gone before the court and the court has denied that, and they decide to take that same document and file it with no new evidence, no new information, then that will get denied again, because they're just essentially unduly burdening the court system with the same document. In order for them to come back and they could seek for reconsideration if there's additional evidence, or maybe if they think that their point wasn't made across with the court because the court took something that they said and misunderstood or mischaracterized something that was conveyed, because sometimes it's challenging for pro pers. They may not have the lingo. They may not know exactly what to say. They don't know the motion practice. And so when they're up against someone that is represented, it can be very challenging. And I think that's where it's incumbent on the court to recognize the challenges that our litigants face, to recognize if there's a mom, for example, that's a pro per and she's trying to get custody of her child, but she's up against maybe a husband who has a heavily guarded attorney who's filing motion after motion. The court needs to also take consideration of that.
Mr. Kurth.
I appreciate that question. It's very general, though. It's, without knowing some more specifics on the actual facts. Like, for instance, I can't tell you how many times I've been around the court and say I've had a mom come up to me, or a dad, but usually a mom, and the child's taken away. They're like, can you help me? Can you help me? I can't. My child's not, they won't let me see my child. I don't know what's happening. And I'm like, well, why did they take him away? Was it because of drugs? And they're like, yeah. I said, how long ago? And they're like, 6 months, 9 months. And I'm like, well, when's the last time you used? And they said, today. I mean, I've had that happen to me, said to me, right? More than once. And, people have to take personal responsibility. And a lot of people don't, but I agree that, some go into court and they don't know how to handle themselves, or they don't have the resources to hire an attorney. And then they feel like the judge didn't let them talk or get their say or didn't understand. So yeah, give them another chance. If the judge made a decision and said, look, there's supervised visitation because we have these issues with mom or with dad, and they need to do X, Y, and Z first, and X, Y, and Z hasn't been done, but they keep filing because they're just frustrated. They're like, I shouldn't have to do X, Y, and Z. This isn't fair. Why am I doing this? They don't understand. I'm really the better parent. I just messed up one time, or whatever it is, So it's, I don't think you can just, you have to, I would hear their case. I would listen to them, and I would try to explain my decision properly to them so that they understand it and they at least know what steps they need to do. Because I can tell you through my practice, I tell people all the time, especially if they're dealing with CPS or something, look, if you just do what they're asking you to do, you might not agree with what this judge says. If you just do it, it's going to work out. You can get your child back, or you're going to get custody, you're going to get more visitation, something's going to happen, but it's a process.
All right. So if you're presiding over a TPO hearing, temporary protective order hearing, and it's basically a he said, she said, is there enough to issue a TPO?
I have presided over TPO hearings in my position as an alternate master, and oftentimes it was he said, she said, and the burden of proof is incumbent on the petitioner, the person that filed, to establish what they're setting forth, that they're a victim of domestic violence. And so as a judge, it's challenging because you have to make a decision based on what's in front of you. But what's in front of you, when you have both litigants in front of you, you can assess credibility, you can ask the questions, you can assess the facts. And at the end of the day, the burden of proof is on the movement to establish the burden that they're trying to put forth. I can't answer it without more information that you have, but the role of the judge is to apply the law to the facts, and the burden of proof is on the movement that's filing in front of them.
So I think, I do a lot of criminal law too, and people are charged with domestic violence every day. They go to jail, men and women. You used to think it used to just be men. It's women. Sometimes the woman will call on the guy, and then she's the one that goes to jail, So, and it's a he said, she said. What happened? And they're looking at who the primary aggressor is. I think a lot of times the courts, in my experience, they err on the side of caution. If there's something, specific, if there's been some physical violence, if somebody just threatened something, unless they did violence before and now they're threatening again, they might not grant it. But a lot of times they err on the side of caution. Plus, the burden was to the satisfaction of the court, which is like nothing. Hardly anything. But, they did just change the rules, I think, or something came out and they're actually saying, and I always compared, technically satisfaction of the court is whatever the judge wants to do. But now they're saying probable cause. But even probable cause is a very low standard, right? You just got to think that it's that they probably committed this act. They probably did what is alleged. So a lot of good times is to have a hearing, right? So if you're questioning that, then you don't issue that temporary protective order right away, because that really upsets the cart. I mean, it puts one person out of the house. Now it gives the other person a lot of control. A lot of people are doing it because it's a custody case. Oh, I need a one-up now because this TPO could be considered to create a presumption that has to be overcome on who should have custody in the end. So you have to deal with it very carefully on a case-by-case basis. But if there's any question at all, you don't even want to issue it. You want to have a hearing first. If there's something and you issue it, then you have the hearing to see, okay, am I going to extend it? Is it going to get dissolved? And let the litigants know how to do that.
If you had a situation where one of the attorneys went in to freeze the opposing side's bank account without a court order, and it was brought to the judge's attention, or yours in this case, what would you do to that attorney as far as censuring them when you were speaking of them having to have this oath, and you have to uphold that and decorum in your courtroom and all of that? So what would you do to that attorney if you found out that they did that?
Again, I need more, everything is so fact basis, right? That's very general. I could see an attorney possibly like you're having a divorce and people have assets, and then a joint preliminary injunction is issued. And the attorney's sending a letter maybe to the financial institution with a copy of the joint preliminary injunction, which is technically an order saying you can't dispose of any of these assets, right?
There was no order.
Right. Well, if they didn't have any basis and they're doing something, that it sounds inappropriate and improper to me. I'd have to have the evidence provided. There's a series of rules and laws on how you need to do, like to have an order to show cause and then present it, and if it is, and have a hearing based on that. But sure, if that's going on, and it's probably incumbent on the other side to bring that to the court's attention, right? So that could be considered later on, and however you make your final decisions.
I have one clarifying question. Is the other side, the attorney filed to freeze the assets of the party? The other party, though, is that party represented or is that a pro per? Both represented. Okay. The reason I ask is because both attorneys are subject to Rule 11. And so, as I mentioned earlier, the court has a duty of care and has a duty to actually hold these attorneys accountable to Rule 11. And so if a JPI, a joint preliminary injunction, was violated, or if they filed something, or if the other attorney did something and filed something to freeze the accounts, I would issue an order to show cause for that attorney and both parties to appear before me to show cause as to why they did the actions that they did, and to ensure that it's rooted again in law and make a decision at that point. But it would be incumbent on calling them forward to come and show cause as to why the assets were frozen and whether that was in accordance with the JPI or whether that was in violation.
Okay, so I guess obviously not an attorney, but one thing that really confuses me about family court, and I hear this from a lot of people, and I think they're confused as well, and this is the reason why I want to know both of your opinions on this. Is it so I brought up a lot of pro per litigants being being considered vexatious, and thank you, Mr. Kurth, for explaining why they tend to get brought up vexatious because they're just constantly filing the same motions over and over and over again. Well, it's always kind of confused me, and maybe I would like both of you to explain this to me. Then if people can't afford an attorney, how come in family court one can't be appointed to them? Why is that? Why does that not happen in family court? Is there something about the law I don't understand about that? Because wouldn't it make it easier on both sides? Especially, Mr. Kurth, you've practiced family law, and I'm sure you've went up against pro per litigants and get a little frustrated at that process. Wouldn't it be advantageous if the judge could appoint counsel to help represent a pro per litigant? I'll start with you, Mr. Kurth.
Okay, thank you. Thank you for the question. You know, there's a lot of different scenarios there that you could talk about. So I can tell you a long time ago, years ago, I wondered why these families, and I'm going to bring in the CPS, the Division of Family Services, involved in that. And, you know, the parents are looking at losing their kids, right? It's very hard for me to file a petition to terminate somebody's rights and in private practice and represent somebody and get a judge to do that. That's very difficult. But they slam those through all day long in CPS, you know, in DFS and in that court. So years ago, they didn't have an attorney, what would happen is the child would be placed with a relative, right? Like the grandmother or a sister or somebody like that. And the mother or the father who had the case, they just got comfortable. And then they didn't complete their plan, and then they're going to lose their kid, or they just assigned the child over to the other family member. Well, then they started appointing them. So now they can have an attorney. They have an attorney appointed to them to represent them, which is tremendous. I was so happy when that happened. And then they also have attorneys that can be appointed to represent, or you can have a guardian ad litem or a cap attorney to see what's going on with the children, right? To make sure that's going okay. Now, in your regular divorce proceedings, okay, now in those proceedings, they're taking away somebody's child. They can terminate their rights, right? Their constitutional right to have this child. So that's why they're getting an attorney appointed in that situation. In a divorce proceeding or a child custody proceeding, if somebody doesn't have the income or the resources, Clark County Legal Aid, they can get an attorney, but sometimes people have the resources and they still give them an attorney. But when they're not paying an attorney and you have an attorney on the other side, it's very difficult to negotiate and resolve cases because most cases get resolved, right? 90% plus cases get resolved. But when you're dealing with a pro per litigant that has a free attorney, they don't have any incentive to resolve anything usually. You know, maybe like even somebody that's charged with a crime that has a free attorney and just says, well, I might as well just go as far as I can go, right? So it can cram up the process too. So I gave you that background, and my short answer to the question is, you know, in a divorce or a custody case, they're just not appointed. But what is good is you have a ruling like Sargent, okay, or Miller versus Wilfong or something like that, that gives the opportunity if the judge gives them, right? If the dad comes in, and I've represented a lot of mom, like, they come in, they took all the money. She never even knew what the bank accounts were. She doesn't know what business they were in, or vice versa. Okay. And they didn't pay any bills. And how are they going to get an attorney to represent them? And the other side has it. Well, these cases and the case law allows the judge to order the other side to pay attorney's fees and then to help them to be able to have that representation.
Mari.
That's okay. So you bring up a good question, and I have two-part answer because I think your question was, shouldn't the court do this? And shouldn't is different from whether, you know, in an ideal world, I would say yes. We should have attorneys for everyone because that would make things easier, supposedly, especially if they all follow Rule 11. However, what we're looking at is governmental interests. And, you know, for the court to appoint counsel, it has to be because the person is standing to lose life, liberty, or property, right? Like if you're charged with a crime, you get a public defender because you stand the risk of losing your freedom. In what Robert was describing in CPS cases, you get appointed counsel because you stand the risk of losing your parental rights or even losing the right to care, custody, and control of your child, albeit even for a season. So in the CPS cases, counsel should be appointed, and they are for parents and children, because children, we can't forget the children. You know, they get torn and lost in the whole shuffle. Children need to have attorneys as well in these child protection cases. Oftentimes, a lot of people use CPS cases as leverage to go into family court because they'll call something in on the other party and try to get government involved, try to get a governmental a record against a parent and then use that as leverage. I see that all the time. I deal with the appeals from the parents, and I can see right through it when it's something that looks like a coaching case or it's posturing for custody court. So I overturn the substantiations, so there is nothing on the record from CPS. This needs to go to custody court. Also, when I was a judge as a hearing master, I saw that oftentimes. So When you're standing the risk of losing life, liberty, property, i.e. parental rights, the state must appoint counsel. But when you're dealing with one litigant after another, that's considered a civil matter. So the state or the court doesn't have a duty to appoint counsel unless you have these circumstances where there is an uneven playing field, such as what Robert just described. And then the court does have the discretion to appoint at least attorney's fees so that the party that's not as equally yoked can hire counsel. We do have some resources. It's not enough. Legal Aid Center of Southern Nevada provides counsel. There's also opportunities in those hearings to appoint guardian ad litem. There was a divorce hearing that I was appointed as the guardian ad litem for the child. It was a parental alienation, i.e. and an abduction case, and the two parents were coming at it. I was appointed to be the guardian ad litem for the child to speak for what's best for this child in the midst of a custody court case.
Do you think it should be mandatory that family court judges are all parents?
Mr. Kurth, if you want to go first. Yeah, sorry, whichever one wants to go first. I know that's a loaded question. Either Maury or Robert, either one.
A loaded question. So I think it's important but I don't think I can't say it's got to be a mandatory requirement, okay? But I think it's important because in family court, what people doing is they're blowing everything out of proportion usually, okay? If something's really big, they're making a mountain into a molehill. Like I had one case one time, I remember they were like, oh, the person's arm got caught in the lazy boy when they were putting it down or something. They didn't intentionally catch their kid's arm or, they're being negligent. They should be paying more. There's a million things, right? Things happen, Your kids can go up, they can go out of town. They could go outside and play. They can fall down. They can get a bruise on their leg. I think having kids and raising kids and dealing with the different issues at the different ages is extremely beneficial because every child's different and you're seeing them. I have 4 children, okay? My youngest, my oldest is a school teacher. And, my son is an officer with Metro. My other daughter's a dental hygienist and my other one's an esthetician. But they've had all so many different experiences and provided different experiences for me. And now I have grandchildren too. And that's a new thing. So I think that's helped me to see their friends, other things that have happened, things that have occurred, to see how difficult it is to these things come up. What if you have a single parent? How difficult is that for them to, the child's having a problem or has a blowout in their diaper or, is sick and maybe they're all by themselves and they don't even have anybody to hand the child off to help them for a minute and they need to run to the bathroom. There's a lot of different issues. So I definitely think that having children and going through that and dealing with those day to day through the school and the relationships they have with their friends and just everything makes a better judge in understanding and looking at what's going on. Because I can tell you, I'll finish this up, but is that perception is reality. And people that come before the court, they have a certain perception. Their perception is their truth. It might not be the real truth, but it's their truth, right? And then you have to try to wade through all of that.
It is a loaded question. And, the judicial canons don't set forth or the requirements. The law doesn't require a judge to be a parent for family law. However, the decision on who serves as the judge is the voters' decision. And so I believe the voters should get to know who's running and see if they have an ability to understand what their litigants are going to be going through in front of them. Life lessons are very important. Life experiences are important. If you're going to be tasked with making decisions about families, then the judge should have a level of understanding to understand what their litigants are going through, especially if it's maybe a single mom who's losing a job and doesn't have the ability to provide for the wherewithal for the children. In CPS, I remember Judge Sullivan would always tell me, we don't take kids away from parents due to poverty. If it's a single mom working 3 jobs, trying to make ends meet for her children should not be taken into protective custody because of that. Instead, what we need to do is come and meet her where she's at, find out, are there relatives, are there family members, are there people in your community that can come alongside to support you so that we can help you. You don't have to be a parent to do that. The judge doesn't have to be a parent to do that, but the judge should have some sense of compassion and empathy to understand the challenges that the litigants are going through. And instead of just throwing the book at them or throwing the law at them, let's try to see how we can help. The families come to the justice system for help. They're coming to ask for a decision from a neutral, impartial arbiter who can make a decision, and I believe with a heart of compassion, so that we can come and look at it through the lens of the families in front of us.
Okay, well, thank you very much, Maury, for leading me into my next question perfectly. You set me up perfect. Okay, so this question is for both of you. Yes, it is Nevada state law right now that all judges are elected. Okay. So we here at Veterans in Politics have proposed a bill in the last legislative session. It did not make it out of committee, but we are going to put it forth again. And the name of the bill is Remove or Retain. And this is specifically how that works. So if you are running for judge, okay, and this only applies to incumbent judges, though. If you're an incumbent judge and you're running for re-election, okay, and no one opposes you, okay, right now, currently, in a sense, as long as one person, and hopefully that person running for judge would vote for themselves, they automatically win. Okay. So what remove or retain would do is that if that's the situation, then the incumbent judge's name will appear on the ballot. And then right below that ballot, it'll say remove or retain. Then the voters can decide, do we want to remove this judge or do we want to retain this judge? If retain gets the majority, then okay, that judge is reelected. But if remove gets more votes, okay, then what happens is that attorneys or anyone who is qualified to be judge under Nevada state law then fills out an application, the application process, turns the application over to the Judicial Selection Committee. They choose 3. And then those 3 go to the governor, and the governor then appoints that individual as judge. Would either one of you support that type of legislation? The reason why we are putting forth that legislation is because what we've found is happening is there's a lot of incumbent judges that really hold a grudge. And a lot of good attorneys are afraid to run against that sitting judge because they know if they lose, they're going to have to at some point probably go in front of that judge, and they're afraid of retaliation. I would like to get either one of your take or both of your take on whether you would support that remove or retain bill. Whoever wants to start. Maury, if you want to go ahead.
As a judge, we're not allowed to legislate from the bench. So I believe the question you're asking me is in my personal capacity, not as a judge, correct? Okay. In my personal capacity, I understand the concept behind remove or retain, especially with regard to the incumbents, ensuring that this is something that the voters want to retain, or this is someone the voters want to retain as opposed to remove. That would make a lot of sense. It's in the interest of, again, putting it back in the hands of the voters. That I would support, and I would come alongside that. The challenge I have, though, is the downtime and the delay, because if this is on the ballot and if we're on our regular cycles, for example, right? And are you saying at the primaries, if it's an incumbent judge, no one's running against them, there's remove or retain. What if it's remove? Then what do you do? Because now there's an empty seat, and do we want to give that? You're taking it away from the voters is what I'm saying. because the person that's going to fill that judge's seat that's going to be removed, it's not going to go to the voters. Instead, what I'm understanding is it's being submitted to a judicial selection panel and then being submitted to the governor. And I just wanted to kind of double check and clarify that was the intent behind the second half.
Well, I mean, that judge would stay in place until the election. So that wouldn't be an issue. The judge, even if they got removed, there's still a sitting judge at that point. So that wouldn't even start until the election process.
Okay, so the removed judge would continue serving as a removed judge until such time as the replacement judge would come, but that replacement judge would not be decided by the voters. It would be decided by the governor.
Yes, that is correct. Mr. Kurth?
Clarifying question. Who is making the decision to remove or retain?
It's the voters. It actually is on the ballot. Remove or retain. So remove or retain is actually, that decision is actually being made by the voters.
I think they're already, it's a little confusing to me because I think they're already making that decision. So you have a lot of incumbent judges. You've had judges in the past who've got very low ratings, very low scores, or other things, and other people have tried to run against them, and the incumbent judge still wins. So I would think that they would probably just end up being retained in that type of situation that you're expressing. It seems like the concept of it, I don't have an issue with a system where judges are appointed and then there's a determination whether or not to, remove or retain them. And I get what you're saying is it's even if nobody's running against them. But the problem is if nobody's running against them and the voters are going to say remove or retain, when they have somebody running against some of those incumbent judges that some people think should be removed already, they seem to win anyways. So I would think that they would just get retained. But the whole concept, coming back to it, I don't have a problem with that. I think if somebody is a judge and they need to do well, right? I mean, you should be following the law. You shouldn't be doing some things that we've seen some judges be removed from for doing in the past.
Okay. Well, thank you both.
Veterans Treatment Court program, I understand, used to be free of charge to the veteran, and now they're charged for that. Is that correct?
I don't know. I haven't had somebody in. I've had somebody in the Veterans Treatment Program, like in the Henderson courts, and I've looked at some other courts. I really don't know. I haven't had anybody recently. It's a pretty rigorous program, and quite frankly, and sometimes in negotiating, something like, well, you can go to Veterans Court and this can happen and we can get this, but I can also get you this. And it's not as, they don't want to go through all that rigor and everything, but it could help them to do it. So I'm not aware of a charge. I'd have to look into that, but I don't know that they should be charged. I mean, right? We're providing these services for them to be able to come and do it. So I don't think there should be any charges for that.
All right. So if you're aware that a fellow judge, oh, sorry, did I interrupt? Oh, I apologize.
Only if you wanted me to respond to the Veterans Treatment Court. I'm not aware of the charging or not, but Veterans Treatment Court is incumbent. It's important for our veterans. Our veterans served our country. They served at the behest, them and their families. So when we have veterans, especially I have my husband who's a veteran who served. He's disabled. He's hurt. He needs support. And the VA is not the only thing that should be wrapping around supporting them. It should be the courts, especially if it's now landing before the court, if it's affecting custody, if it's affecting a parent's visitation or their ability to parent their child because of the exacerbation that they incurred while serving our nation. There should be treatment, and it should be free of charge. We have resources in the community. We need more. And especially when it comes to Veterans Treatment Court, that needs to be a priority.
Well, since I'm the one that keeps asking all the loaded questions. Huh? Oh yeah, no, this will actually, and Steve's laughing as he's watching us right now. He's going to say, yeah, here Jim goes again with this one last question. But I promise this is my last question for you guys. And the reason why I'm going to make it my last question is because it is a loaded question. One of the frustrations that I hear from people that have been involved in family court, either voluntarily or involuntarily, is this idea of the best interest of the child. And when it comes to family court judges in general, I know our organization has been pretty tough on family court judges. Not all, but quite a few. We have been pretty tough on them. I'll be honest about that. And I think part of it has to do with the fact that the amount of leeway that family court judges are given. So really what I want, and I'll start, Mario, I'll start with you on one side, and then we'll go to Robert. I just want I'll give you both a couple minutes to explain what you would do as judge. What are the considerations that you're going to look at when you think about the best interest of the child? What does that definition mean to you as a judge? And I'll start with you, Mari.
Absolutely. Thank you, Jim. The best interest of the child is the paramount concern. And having sat as an alternate master for almost 4 years, that was the overriding concern in all my cases, whether it's child abuse, child protection, domestic violence, TPO, it was always the best interest of the child. And a lot of that, we have statute and we have case law that provides us the factors that we can look at for the best interest of the child. But still, what we really need to do is take a look at it from the eyes of the child. The best interest of an infant is going to be different from the best interest of a 17-year-old. So we really need to come and meet the children where they're at. And I think this is where being a parent does come into play and is very helpful, because having parented and raised children who have grown up, moved out of the house, some of them followed the rules, some of them didn't, you can understand that the best interest of the child is not what I think they should do. Like as a parent, right? You have your set of rules. This is what you need to do and follow it. That's not the best interest of the child. That's your rules and what you expect. As a judge, we need to look and not, instead of imposing our expectations and beliefs on the child, we need to come and really assess what's going on with this child right here, right now, holistically. How is their emotion? How's their education? How's their psychology? How's their bonding? How are they if it's a custody case? How are they when they're around a parent? Have they grown up and been with mom? Is it because mom alienated dad and kept dad away? We need to give the child an opportunity to build a relationship with dad. We also have to look at the child's support systems. Right? Is the child isolated when he or she is with mom all the time, as opposed to being with dad? There's a family, there's a support system. So we need to really look at the whole assessment of the child. What's in their best interest? How's their health? Who's providing for the best care for them? And also ask the child if they're able to speak. Ask the child. That's where I think CASAs and CAP attorneys are helpful in child protection cases. But in custody court cases, the court can also appoint a guardian ad litem. I served as a guardian ad litem in a highly contested custody case, and my charge was the best interest of the child. To get to that, I had to meet with the child and ask the child what she wants, and then assess that against everything else.
All right. So if you... Oh, my.
You want me to do that? You want me to answer that?
Yeah, go ahead.
Okay. No. I understand your question. I understand what you're asking, because when the courts go through the statutory factors and they're looking, has there been a nomination by the parent, right? Does the child have other siblings in the other relationship, right? What's the ability of the parents to meet the needs of the child? What's their willingness, or how are they communicating with each other? And you have, has there been any domestic violence and abduction, so on and so forth. But you have that big factor in the middle that pretty much allows the judge a lot of times to move it into that big factor, right? Which is, what are the physical, developmental, and emotional, right, needs of the child, or who's taking care of those things? Who's going to help them develop in that matter? And that's what you have to take evidence on. And you have to look at what is in the best interest. And it's difficult when if you're doing a guardianship case. Did you know that if the child's 14, there's a statute that says what the child wants is going to not be necessarily conclusive, but you have to listen to that, right? We don't have a statute in the custody that says that there are certain age you have to listen. But if you're 14 and you say, I want this person to be my guardian, the court has to take note of that, serious note of that, okay? And different kids at different ages are at different levels in development as far as interviewing them, finding out. And kids also manipulate the situation, right? They can manipulate it, or what's going on with the parents manipulating. So you have to be able to see through that. And I think a good judge has to have that experience that they've been going through that, doing that, so they can try to make the best decision they can. It's better if the parents would go get it worked out together, right? But people don't understand, hey, we have this relationship, we're having a child, and guess what? Oh, things aren't going to work out now after 2 years, but well, guess what? You're probably going to deal with each other the rest of your lives and your child. And nobody thinks about that, you know? I mean, kindergarten graduation, high school graduation, college, marriage, so on and so forth, right? The rest of your life. So it's the best thing to try to help guide them so hopefully they can co-parent, which is extremely difficult for some people. But again, going back to it, the best interest of the child, that one factor there, the physical, developmental, and emotional needs of the child is the most important that you need to look at, but you need to parse out very specifics and try to take as good evidence as you can.
Just following up on that question now, what is the best interest of the child? If two parents are getting divorced, there's always a he said, she said element, but there's, they both seem like decent parents. What is the starting point for that custody of the child? If you want to go first, Robert.
Well, the starting point, which is, a lot of things have changed since I started practicing law in 1992, when pretty much somebody, let's say the dads would get every other weekend and they'd be paying $500 a month child support. Okay, that was pretty standard schedule back in the day, right? And then now child support changed and doing an offset. So and then we went to a 60-40, right, with Rivero. So if you have 40% of the time, you're getting that offset on your child support, where somebody before, if they had the child 51% of the time, they're getting the full child support, everything goes. And people say child support doesn't matter, but it's all behind the scenes. It's all matter. It's all affecting it. People are litigating. They're looking at how much that's going to cost. I think I got past your question, though, talking about that. It was, where do you start at? Yeah, so now we have in the law, I was going back to the past, it's presumed that it's written into the law now, right? Not just in the case, but in the NRS. It's presumed that it's in the best interest of the child for the parents to have joint legal and joint physical custody. So that's the starting point, right? Somebody has to prove that the other parent cannot or is not incapable of having the child for 146 days a year, which is 40% of the time. So that's the starting point. That's where I'd have to start. That's where I would start. That's the law.
The best interest of the child is highly fluid. It's fluid. It changes on a day. It could very well change on a daily, monthly basis. And so as a judge, our role is to apply the law to the facts. And as Robert, I'm sorry, I keep saying Tom. As Robert mentioned, this. I'm sorry. There is a preamble in the statute that does make the presumption that joint physical, joint legal. And so if a parent is coming forward to move for sole physical and sole legal custody, it's that movant's responsibility to establish that by the burden of proof. And so I think this is sometimes where it gets challenging, is because the judges are held to a standard of applying the law to the facts, but we also have to put some onus on the litigants in front of us to establish, help me make a decision. I had to make decisions when I was sitting as a judge for child protection cases that involve custody. Oftentimes, the role was, number one, removing this child to ensure the child's safety. If the child was in the care of mom, for example, and mom was an unsafe parent, dad didn't have much of a relationship with the child. Let's convolute it more. Dad was a service member, so he was out on military duty. And so now I find that this child is not safe in the care of mom. I remove the child from mom. Now my goal is to try to replace the child with dad, but dad doesn't have a relationship with the child. Not to his fault, because the child has been alienated from him. So my role there is to balance the interests of this parent, mom, and dad, and then, of course, looking at this child. I had to look at first this child's bond and this child's relationship. This child had a relationship with the siblings that were with mom. And so the goal was to assess trying to keep the family home together. Maybe was it to an extent that maybe mom could still stay in the home if there were some supports in the home, putting safety plans in there, putting grandma, auntie, uncle in the home, so that it really wasn't a case of mom being abusive or neglectful. She was just overwhelmed. She had 5 kids. She was the only one doing everything, and she could not make ends meet. And so now we look at it to try to wrap the mom in services so that we can keep this child in the home with her siblings together while also bringing dad into the mix and allowing this child to build a relationship with dad. My answer is it's fluid. There's no cookie cutter answer for what's the best interest of a child. But what we have to do is constantly assess the best interest of the child on day 1 of the court is going to be different from 5 days later, 4 days later, because we have to follow the child and assess the child's relationship with the parents. We're not looking for perfect parents. There's no such thing. We just need to ensure that the child is safe and with a parent that can be a fit parent for that child.
Okay. Yeah, go ahead.
Okay. So if you're aware that a family court judge is doing something improper, like showing prejudice, for example, they're clearly biased towards one parent, or they have perhaps racist feelings towards, which I've seen instances where, racially insensitive statements have been made towards one of the litigants. Would you report this to the Judicial Disciplinary Committee? And if you want to go first, Mary.
So hypothetically, you're asking me if I was already a sitting judge and I was aware of a colleague who was making racial slurs or whatever your examples were. I guess my clarifying question would be, first, how am I aware of that? Was it just he said, she said to someone? Was it a litigant that came to me and complained? Or did I actually watch it or see it on the tapes?
Let's assume you actually saw it on the tapes, or you heard it where you had clear and conclusive information that showed that that person was behaving in a prejudicial manner.
Thank you for the clarifying question. Well, first, I would talk to that judge, because before I would go and report that judge, I would let them know, hey, you know what? I saw this. What's going on? Maybe I'm not excusing that judge's behavior at all, but I believe that they deserve at least to know, listen, I saw this happened. What's going on? Let's get some help. Sometimes maybe they're going through other crises and maybe they shouldn't be sitting on the bench at that time. Now, if the judge refuses and, is in denial and says, no, I'm fine, I don't know what the problem is, then I'll absolutely have to go and report it and take the precautions, because at the end of the day, it's these families' lives at stake. And these families' lives should not be in the hands of a judge who's not in a position to make impartial, fair decisions. These families deserve justice.
Robert, did you want to tackle that, or?
A judge needs to be impartial, right? Unbiased and fair. You have to have personal knowledge, right? So a person has to have personal knowledge. And I think in most of those cases, if that happened, that the litigant's going to have that. It's going to be on the video. And they're going to present it, and they're going to take care of it. They're going to be doing it. It's already going to go to the Judicial Ethics Commission and be resolved. If I heard a rumor or something like that, I would want to go down and discuss that, because look, I've been doing practicing law for 30 years, and I don't want to say there's 2 sides to a story or 3 sides or 4 sides, or there's a lot of different sides to the story. But if it's clear and blatant, and I have personal knowledge of it, then I'm going to have to look at my ethics and my canons, and I'm going to take the appropriate action for that.
Oh.
Jim, you did your last question already.
Oh, yeah, no, I'm good. That's what I'm just...
So can one of you explain what the Service Member Civil Relief Act is?
I actually was subject to that when I was ruling on a custody case, in a child protection case. And the Civil Member Service Relief Act is, if we have our soldiers that are deployed and they're serving in duty, and a case comes against them, it should not be to their prejudice, meaning ideally it should be paused. We need to ensure that their rights are not prejudiced. Someone can't come into court, file a divorce, clean out the bank account, get sole custody of the kids, and do all of this while our military is serving our nation. That's the whole purpose, is to protect the rights and preserve the rights of our soldiers. The challenge comes in the application of that. I'll give an example for me. When I was presiding as an alternate hearing master for a child abuse and neglect case, I had to remove the child from that mom. The dad was a civil service member. He was deployed. I couldn't pause the case and tell everybody, wait, we're going to wait till he comes back. I couldn't do that because I had to focus on the protection of this child. I also couldn't order him to leave his duty station and show up here in court because he's defending our nation. So I had to balance the interests here. I have his interest that he has a right to be protected as he's out on duty, and the interest of the child. The best interest of the child was my paramount concern. What I did in that case is I removed the child from the mom because the child was not safe with the mom. But to preserve the father's rights, I, of course, appointed counsel for the father. And I asked the child welfare agency, because it's their duty, if there's any paternal relatives. Is there grandpa, auntie, uncle, anybody that's the circle of support for dad? Let's go find out who they are. Let's bring them here to court to see if they'd be willing, if dad wants them to. Again, I have to do what dad would want. If dad wants his mom, if he says, I think in that case he did. So I found paternal grandmother. She came in court and she said, yes, I talked to my son. I want to take my granddaughter until such time as mom works her case plan. And so dad's rights were preserved. His familiar rights were preserved. And when he came back, he was able to continue with his case.
That is an important act, and it's not only applicable to family court, but it is written specifically to the Nevada revised statutes in the family court, which is great. It's very important, but it also applies if somebody's just being sued even, right? So somebody can't get a default judgment, take their house and everything else. It's my understanding that the person serving has to be deployed. Like they can't just be, if they're just stationed out at Nellis and they're, if they're doing something that's confidential or they can't come or do something, then they can get something from their superior officer and present that. And I would consider that. But yes, it's very important to try to keep somebody from being taken advantage of in that situation.
So when you have service members that are deployed like that, there's been judges in family court that have abused litigants while they are deployed. And one, for example, told this deployed member to go, he was in combat, active combat, to go find a base where he was not in active combat so he could call in to appear to a hearing in his courtroom. Would that ever be something that's appropriate from a judge's position with a deployed member in combat?
I can't think off the top of my head right now. I can't think of a circumstance where it would be, because that's going to change that person's psyche, could put them in danger, could put the other people that they're serving with in danger. It's going to have a rippling effect. A lot of times what we don't understand is our actions don't just affect us. They affect others, and people don't realize that when they're making that decision. So I can't think of a reason to do that off the top of my head.
And I couldn't agree more. The answer is no, it would not be appropriate. The Civil Service Members Relief Act is in place for a reason, to protect our service members when they're in the line of duty, deployed to defend our nation. Their rights need to be preserved, especially in family court, when it's the most vulnerable, when it's dealing with their own child. And so I gave my example already of how I applied the law to the facts to preserve this parent's right. And I believe that there's plenty of other opportunities out there to think creatively. Maybe in some cases, as judges, our hands are tied. In that case, I could not pause it. I couldn't say, we'll wait till he comes back. But that's where you take judicial leadership and you think outside the box to focus on, how can I serve this family? How can I serve this child, protect this child, meet the best interests of this child, while balancing and honoring our service member who is deployed and serving our nation?
And if you had a service member that was deemed 100% disabled, as a judge, would it be inappropriate to tell that service member, that litigant, that you can work just because they deemed you 100% disabled? You need to go be employed. Would that ever be appropriate?
you hit a sensitive spot for me because my husband is 100% disabled and he cannot work. And that life experience for me gives me a different lens, especially as I'm going in family court, because our veterans served our nation. And not just our veterans, but the spouses and the children having lost their husbands or fathers as they're out and deployed, lost that time of growing up. And then when they come back, they're disabled and they can't function. They can't even do daily functions. So it absolutely is not appropriate. And as the judge, our role is to uphold the highest standard of the law. And if they've been already deemed disabled by the Veterans Disabilities, and I can tell you, I know, to get 100% disability, you don't just get that. You have to fight for it. They will, even if you're disabled, they will release you honorable discharge at 10%. And the veterans have to continually fight to get that 100%. So as a judge, I would have absolutely no right to tell a veteran that's 100% disabled in my courtroom that he has to work or she has to work.
If somebody's determined to be 100% disabled, I would just think as a matter of law that you can't do that. I mean, I can't imagine what it's like to be in an active duty and to be gone, or like people that were in Afghanistan for so many years or so many tours, and then they just got to come back and try to mold back in to society. It's got to be an extremely challenging process. So if they're disabled, they're disabled. The thing is that there's a lot of people that you see that are 100% disabled. And, you know, it's like you pull up to the grocery store and somebody parks in the handicap spot and you're like, oh, well, what are they doing? Or why are they doing that? How some people react. But maybe they're the one that has a disabled child, you know, and they deserve to be able to park there. Or maybe you just can't see what's going on. You don't know what their disability is. You don't understand it. And you can't make, you can't make a supposition. You can't make a determination about them and think, well, obviously somebody made that determination and said they're disabled. So they determine they're disabled and they're 100% and they can't work. They're entitled to these benefits.
And there was an instance in family court where there was a veteran and he was not able, the mom was keeping his kids away from him, not following court orders and not bringing the kids to him when she was supposed to. He would file motion after motion, and the judge did not enforce the issue, didn't enforce her to take the kids to him. He ended up committing suicide because he was alienated from his kids and went into depression and all of that. So these instances where I've been telling you about the judge, to me, that's abuse of power. There's a lot of discretion from the judge's bench, and they can pretty much say whatever they want to. I mean, yeah, there's laws, but these things that they violate, and they're immune from prosecution and all of this. So where are the judges? How are they being held accountable? And I believe that there should be somebody sitting in every single courtroom, and watching these judges, making sure that no one's constitutional rights are violated and that the judge is actually acting appropriately. So I want to know how you feel about that particular case, about qualified immunity, and how you feel about somebody sitting in your courtroom and watching over you to make sure that things are handled in a proper manner and that these things don't happen anymore in family court against litigants, especially our veterans.
Whichever one of you want to start, Ari.
Especially our veterans. I couldn't agree more. What you just described is a travesty, and it's our system failed. Our veteran who fought for our nation and fought for us. There are canons that the judges are held to, and judges are public servants. I know that's the core of being a judge, is you're serving the public. It's not they're here to serve us. We're here to serve you. And so in this case, for example, what happened was a complete failure of the system from start to finish. If I were a litigant in that case and I experienced a judge abusing power or anything of that nature, one, I could file a motion to disqualify if there was a basis, if the judge made slurs or anything of that nature. We filed one for a motion to recuse a judge because there were some clear violations that harmed our case. And when we filed that, it gets filed to the judge and to the chief judge as well. And it's typically also filed to opposing party, but because it's a child protection case, we filed it with a motion to seal to protect the identity and protect some of the disparaging information. And that was presented to the chief judge and to the judge whose behavior was questionable. And immediately our motion was granted and we were moved to a different court. Litigants have that opportunity to file for those documents, to move to a different court if they're subjected to any type of abuse, in addition to, of course, filing. Your second question, though, was regarding court monitors and how would I feel about that, I believe was yours. I think it was a two-part question. And actually, I was subjected to court monitoring, and I liked it. When I served as an alternate hearing master, that was when our Child Abuse and Neglect Court was trying to get the designation from the National Council of Juvenile Family Court Judges as a model court. And as a model court, we were held to a higher standard, and we had bench cards and all of these, factors that we had to ensure that we're addressing in a child protection case. Granted, when your calendar is, flooded with, you have 50 people on calendar for the same time slot and then another 30 for the next half hour. So we're trying to move through there. We had court monitors watching and grading us on our decisions to ensure we were addressing the bench card, we were addressing the family, we were engaging the family, we were actually addressing each family for where they're at and not putting a rubber stamp on every single family. And I welcomed it. I think it's important. I actually said that that's one of the things that we will need. Unfortunately, resources are an issue.
All right, Mr. Kurth.
Trying to remember the exact question. Our courts are open and public, okay? Our judges are elected. We talk about an appointed system. We talk about remove and retain here. The judges are elected. So if they're not doing their job, there's so much social media and everything else out there now, then there should be enough that you can actually end up having them voted out. That is what should occur ultimately. There have been judges that have abused the process and done things, and they've been punished. And there's a high standard that you have to meet. There's a high standard for attorneys that we have to meet. A very high standard that we're subject to in our ethical canons and our judicial canons. If a judge isn't complying with that, then they should be removed if that's what needs to happen ultimately, if that's the ultimate discipline for how severe whatever they did.
All of these things that I've brought up tonight are things that actually happened by judges in our system here. And it seems like they don't ever get removed. I mean, I don't understand how bad it has to get before they're actually pulled off the bench. I mean, yeah, we elect them and vote, but sometimes that's not quick enough because they abuse way too many people over and over and over. So when is that line drawn and said, okay, you can't be on the bench anymore? There's really no oversight, honestly, with judges.
Okay, if either one of you want to just give your opinion on that, and then and then after that, I'll give each of you your minute and a half to close. If either one of you want to give your opinion on that. If not, then I'll just move to you guys' closing statements. Mari, if you want to go ahead and give your closing statement. You have a minute and a half of why the voters should go out and vote for you, why you're the best person for the job, any contact information you want to give out. Mark will zoom in on you if you want to look directly into that camera over there. Go ahead. You have a minute and a half.
Thank you so much. I'm Mari Parlade, and I'm running for Family Court Department A. My heart is to represent the children and families in our community as a public servant, as an impartial, neutral arbiter, to apply the law to the facts with a heart of compassion to meet the families where they're at. I've worked as a children's attorney. I've served as a alternate court hearing master for almost 4 years for different courts, from abuse and neglect, delinquency, TPO, domestic violence. I've seen the challenges that our families have faced firsthand. I've worked with the Child Welfare Division, seeing the families and the challenges they're facing firsthand. I recognize that our system has a lot of work to do. And I ask you to vote for me and put your confidence in me as I will go forward to apply the law to the facts and raise the standard for the judicial system. Thank you.
Robert, if you'd like to go.
Thank you. My name's Robert Kurth. I'm running for Family Court Judge, Department A. I appreciate being here today. I'm welcome to any questions. If somebody wants to contact me, you can look at my website, robertkurth.com. You can call me at 702-438-5810, my office. Happy to answer any questions. You can email me. I'm running for Family Court Judge because I care about our community and the place my family calls home. I have 30 years of experience. I also have judicial experience. I've been an arbitrator with the 8th Judicial District Court since 2001. I've sat as an alternate child support hearing master and a small claims court referee. I clerked in the district attorney's office before I became a lawyer for a short period of time. But I've been in private practice dealing with the emotions, the issues, and the muck and the mire that people are drawn through, and how they want to make mountains out of molehills and molehills into mountains. Family court is a very emotional place, and you'll be able to get through and to see that process so you can determine what the best interests of the children are, what the best interests of the litigants are, and help them to come to the best resolution as possible and to make that decision, because your decision is going to have long-term effects. I will do that. I have the demeanor, the fairness, the integrity. And if you want a judge in that department who's going to be courteous, who's going to listen to your concerns, who's going to respect your rights, who's going to enforce the Constitution, and who's going to protect our families, then I'm asking for your vote. Robert Kurth for Family Court Judge. Thank you very much.
Okay, I want to thank both of you very much for coming on. And again, I just want to reiterate how much us here at Veterans in Politics really, we're very passionate about the judiciary, because we as a country are a land of laws. And I have a great amount of respect for both of you for being willing to run for judge and for what you guys do in your professional careers. So thank you both very much for coming in. So with that being said, that will conclude our endorsement interview for Family Court Judge, Department A. Thank you.